at the
Recording in
19th August
progress.
2023 draft committee meetings, closing remarks, and adjournment. So I would request Mandy to give us apologies.
Thank you, Ms. Nkomo. The apology received is from the chairperson, Ms. Binankulu, as well as the Deputy Minister of Justice, Mr. Jeffrey.
Okay. Thank you, Mandy. Honorable members, here are the two apologies from the committee chair and also the Deputy Minister of Justice. Can I get a hand that moves for adoption of the apologies? Honorable members, I don't know if I'm audible.
Chairperson, the apologies are noted.
Oh, thank you very much. The seconder.
Did you second?
We couldn't hear you, Chair.
So I'm saying, can I have the hand? The apologies were adopted. Can you have the hand that seconds the adoption?
Kamelan seconded.
Thank you very much, Honorable Kamelan.
Thank you.
Thank you very much. Can you move up, Mandy? Okay, as the agenda is presented as it is, before we can proceed with our meeting, we would need to adopt the agenda so that we're able to proceed. Can I also have a hand that moves for the adoption of the agenda, honorable members?
Rosina moves, Chair.
Thank you very much, Ms. Minya, Honorable Minya. The seconder?
I second, Chair.
Thank you very much, Honorable Teke. The third item on the agenda, it's the presentation by the Department of Justice. I see here we've got Mr. Rodney Isaac, an acting Deputy Director General, with Ms. Chabisile Mahlangu. So I'm not sure whether the Minister of Justice is present in the meeting to do a political remarks. Mandy?
No, Ms. Nkomo.
Okay, we'll then allow the department, I don't know who's going to present from between the two representatives from the department. You can start. The floor is yours.
Good evening, Honorable Chair and Honorable members here. My name is Doc Mashabane, the Director General of the Department of Justice and Constitutional Development. In the absence of the Minister and the Deputy Minister, I'm leading the team here, and I'm joined by Mr. Isaacs, who's the Acting Deputy Director General, and the other colleagues from the branch. I'll request Mr. Isaacs to and the team to take us through the presentation. I'm not sure if someone in the Secretariat is assisting us to flight the presentation. Mr. Isaacs?
DG, good morning, honorable members, chairperson. DG, Tabasile Mahlangu was had agreed that she would flight. There we are, DG. It's on the screen now.
Okay, you can proceed if you're taking it, and I don't know who's taking it, like Kamu or you, then you can proceed, Mr. Isaac. Mr. Isaacs?
There we are, DG. I just muted myself. My apologies.
No problem.
My chairperson, good evening, and good evening, honorable members. My name is Rodney Isaacs. I am the Acting Deputy Director General in the Department of Justice, and I will be doing the presentation. We also have online, I'm hoping that she is here, Ms. Kamagelo Lekubu Wilderson, who is the Director in the Department of Justice, managing nationally the program and project on maintenance. As indicated on the screen, and as our mandate, as our instructions from the committee requests, that we do the background, that we indicate the challenges, as well as the interventions in the processing and presentation of the maintenance in South Africa. Chairperson, can I get the next link, the next screen? There we are. Now, Chair and honorable members, you will note that we in the department regard that maintenance services as a primary service of the department. It is also acknowledged that it is one of the most complained about services, as we have been experiencing, you yourself have been experiencing, honorable members, complaints from the community. We have, I've identified this complaints which gets consolidated at our department service delivery unit, and these are then submitted to us in reports per province, where the provincial heads then attend to these matters. Now, in 2021-22 financial year, a maintenance improvement framework was drafted, and this framework was approved by the Minister of Justice in March 2022. What stood out in this framework was that a national maintenance working session that is of internal stakeholders first should be held. And that was held on the 9th and 10th of June 2023. During this session, key challenges and strategies were discussed to address and address issues amongst the internal stakeholders. That is the clerks, the court managers, the maintenance officers, the maintenance investigators, other officials in the department, prosecutors, and there we spent a 2-day session on determining what is it that we are doing correct, where are the best practices, and more especially, what is it that we're not doing properly, and how is this affecting the community, as well as our tools of trade, processes, and procedures. Can I go to the next screen, please? Now, the maintenance improvement framework is primarily aimed at identifying current challenges on the maintenance recovery system, and also it is built and developed around the fact that Section 28 of the Constitution, which points towards the best interest of the child being of paramount importance in all matters concerning the child. So we also focused on regional and international framework, which creates an obligation on government to look at these recovery systems, the maintenance as such. I can just say that it is established that maintenance is the third most income for our community out there, third most to than the employed and our grants in South Africa, and so important it actually is. Now the objectives of these previous departmental strategies, that is our Operation Isonlo, Operation Kariunde, other projects and programs that have been building up, all culminated into this maintenance in improvement framework, but on a more polished basis. And this is where we are dealing with these issues in a hopefully more positive way. Can we just move on so that I can just begin to unpack this whole process? Now, maybe you will understand that all these interventions feed into each other. The maintenance framework, the maintenance in Daba, and later on during the year, towards the end of the year, we intend to keep the first maintenance working session was one where we held as internal stakeholders. The next maintenance in Daba will be more where the broader community of South Africa is invited together with our internal selves to come and talk about maintenance. I think the time is ripe. Well, my apologies, Chairperson. The ripe time is long ago past, but we are on a trajectory to improve, Chair. Now, Chairperson, what I would like to present here are challenges impacting on the access to justice. Now, Chair, there are times when people go to court and the respondent is subpoenaed to court. He then becomes the respondent. He claims for transport and everything, and the court pays him. But the applicant or the complainant it normally struggles to get to court and normally struggles to get home. The maintenance officers are required to advise on the possibility of requesting the magistrate to grant permission for reimbursement through subsistence and travel allowance. So the provincial officers and courts have been asked to budget for these reimbursements, and they actually do budget for these reimbursements. A magistrate will not easily turn down such an application because of the fact of the hardship, and then also dependent on the distance. And even if it is just 10 kilometers down the road in a large city, it's still sometimes a 50 Rand taxi that has to be taken, Chairperson. So this facility is available to members of the public and or the people dealing with the applications, Chairperson. Can we move on? So we also understand that there are long periods of waiting time at the courts for the applicants to be attended to. Now, Chairperson, we have processes in place currently, and we are at advanced stages where we are. That's the supply chain stages, Chairperson, and honorable members, where we have to install something called CRAVS. It's called the Court Recording Audio Visual Systems. And these are going to be installed in our courts. They're going to be installed in our criminal courts. They're also going to be installed in our family courts, where it is possible that an official, where it is possible that members of the public, applicants and respondents, can elect to, after they've been served with notice to appear in court, can elect to testify and participate via virtual platform. We also have an application solution named MOLA, that is the maintenance online application, where a maintenance applicant can apply online for maintenance. So many of them is not going to need to leave work, or they can do it over the weekend, or they can do it in the evening. We are working very speedily, Chairperson, to fine-tune this process. And I am sure that soon in this financial year, we will be able to go out on extensive piloting, Chairperson. There is one little technicality. The application requires an oath, and application requires an oath, and we are trying to change the law to build in an undertaking, which is in the form of an oath. That is, I undertake and confirm that the information supplied by me is true and correct. And on the system, once that box is ticked, you've confirmed that in accordance with the law, which states in the Act, and it will then take you to the next frame on the page, Chair. So, Chairperson, we also have a Provincial Efficiency Enhancement Committee. Now, this committee, Chairperson, is a committee chaired by the Judge President in the province, where a number of people serve on. And the challenges all culminate in discussing it from an integrated process. Main role players in respect of maintenance in the Provincial Enhancement Efficiency Committee is legal aid attends, the family advocate attends, social development attends, the judge president is there, senior magistrates from the district court attend during in which maintenance applications are done. Regional court presidents attend where divorces are done, which forms part of maintenance. And so major role players attend this forum, chairperson, where an integrated approach is taken to fast track maintenance cases. Can I go to the next? Okay. So in order, we are trying to, or we are not trying to, but we are ensuring that maintenance resources, that is our maintenance officers and our maintenance investigators, that they are now divided into the district development models. And not necessarily, so one could very well say that to an extent there is a skewed placement of resources. But as our agreement with GTEC, which is the Government Technical Advisory Committee, who is bringing in an advice on how to place them, how to get them to work in our district development models, our DDMs, how and the norms and standards for these key officials. Then we can move forward on a more scientific, more effective basis, chairperson. It will have an impact on the budget, but more effectively impact on the budget than to just have these people or officials placed where they are and dealing with 4 or 5 courts and certain areas being then neglected, chairperson. I am almost done, chairperson. Now, can I get the next slide? Okay. As I just indicated, we do have a lack of human resources. That is our maintenance investigators as well as our maintenance officers. Now, Chair, our maintenance officer is qualified, legally qualified. He or she has an LLB. They then have a right of appearance by way of the Maintenance Act in court. Every court in South Africa has a maintenance clerk, and those maintenance clerks have extensive experience and they support the maintenance officer, chairperson. Our maintenance investigators also have the powers by way of the Act to apply to the banks for information on your bank statements. They have access to not the solar, sorry, chairperson, the cell phone companies in order to get information where the cell phones of the respondents or so are pinging. They have access to the they register the default judgments. What is it now? But anyway, chairperson, they have access to that information of you to see where you are economically active, chairperson. So we have, if you want to put it, ways and means in order to trace you, chair. Our maintenance officers and maintenance investigators, an overwhelming large majority of them have obtained tools of trade now. They are able to work past 4 o'clock at home, where it is much safer than to sit in the courts at night, chairperson. And so can you move on, please? Chair, yeah, I just spoke about this now, that our maintenance officers, that we have a shortage of them and that we are dealing with a rationalization project for maintenance officers in our courts. I actually want to speak about the rationalization of the procedures, but maybe if we can just move on to the next slide. Now, chairperson, what we also have is that a prosecutor is by ex officio, by virtue of him being a prosecutor, a maintenance officer. That is according to the Prosecutorial Act, appointed according to that piece of legislation. We know that prosecutors are really seriously busy with criminal roles in the courts. We know that our criminal roles are extensive, that the NPA has embarked upon improving the skills of prosecutors. So obviously it takes longer to analyze a case, etc. However, there are pockets in our courts in the country where our prosecutors are really helping out in the maintenance courts with maintenance applications, and more especially advising our maintenance officers and maintenance investigators. So we still plan to bring our Director General and our National Director of Public Prosecutions together in order to thrash out this matter of a prosecutor being a maintenance officer, and that to a very large extent we do need their support. However, we do get tremendous support from the senior maintenance prosecutors in the country, Chairperson. So as you will see there is cooperation between the senior maintenance officer. That should actually be senior maintenance prosecutors and the maintenance officers at court level, including training provided by the NPA to maintenance officers and prosecutors, Chairperson. Can we move on? Chair, also, let me see. Yes, Chairperson, our maintenance online application consists of the initial maintenance application. It also consists of the emoluments attachment order application. And the law is very clear, and it says that when a magistrate grants a court an order for maintenance, the magistrate must grant an order for emoluments attachment order. Most of the time, the parties agree that they will pay directly into the account of the applicant in order to avoid this order being served on his or her employer. But when there is a default, the emoluments attachment order has already been granted by the magistrate, and it basically needs to be implemented. So various sets of applications will be included in the maintenance online system. That is the application, that's the emoluments attachment order, the variation order, the arrears order. We are piloting this system at Durban Point Court, Middelburg Magistrates Court, and Taung Magistrates Court. And once we receive our favorable feedback of the utilization of this in the communities in those towns and cities, we will be able to fine-tune and roll out some more, Chairperson. The South African law reform has also done an investigation on the Maintenance Act, and they are done with the investigation. They are now busy preparing their report and submitting that report on their findings, Chairperson. So there is extensive work that is and or are being done by various institutions within the Department of Justice on the maintenance, Chair. Can we move on? Okay, Chairperson, we have situations whereby people in our society are hiding their monies away, and we are making sure that we have that the ethical part of supporting your child is important. One case where we're going to start is by the taxi industry. They basically work on a cash basis. And so we find out that we are unable to do an investigation against a taxi driver and or a taxi owner that owes maintenance. The other part is to upskill our maintenance officers and our maintenance investigators and clerks on how to analyze bank statements And First National Bank has come to the table to offer assistance in helping us, as at the end of September, helping us with this training. We are in the process, not September, we are in the process of preparing an MOU between First National Bank and the department, which we will submit to the Office of the Chief State Law Advisor just to vet for us and to see if we are in good standing with them as far as the law is concerned. And such training will begin as from January onwards, Chairperson. We also have the Department Security Chief Directorate, as well as the Maintenance Directorate, training by the South African Police Services on being able to forensically find the money for our applicants, our vulnerable women and children, Chairperson. So that's where we are, Chair. I think we also embark upon extensive, Chairperson. I would like to think extensive, because in my capacity as Acting Deputy Director General, I'm also the provincial head for the Western Cape for the Department of Justice. I was the provincial head for the Department of Justice in the Northern Cape. So I can speak with lots of passion and authority that we embark on large-scale, extensive public education and communication programs on maintenance in our communities, Chairperson. When we do our outreach programs, we do it on an integrated fashion, where we go out with police, where we go out with social development, we go out with National Prosecuting Authority, DOJ, etc. And they are all major role players in the whole process of maintenance, because police have to serve maintenance orders. Clerks also serve maintenance orders. Sheriff also serve the maintenance orders, and or subpoenas, Chairperson, for parties to appear in court. So we want to foster and build much more improved relationships with civil society. We think that this is where the help can come from. When one think about maintenance online, we know that it's stress to come to the courts. We know it's not comfortable to come and sit there all day. We know that you might come and sit the whole day and maybe not even be helped. We know that you might come in 4 or 5 times before your matter is even heard. So our maintenance online application can be accessed by our advice centers, by legal aid, by NGOs, community-based centers, provided they have the necessary tools of trade to help the person fill in the application form online, upload, scan, email the application, where the online system is of such a nature that when the information is put in correct, the clerk will press a button and a directive letter will be generated. No data typing or typing needs to happen, and that can then be emailed to the respondent as well. If not, it will then need to be, posted to the respondent, which we know is a very complicated affair when one has to post something out in our current day and age. We normally use email, Chairperson. So we go as an integrated approach to we also do exhibitions when our minister comes, or our deputy minister comes, or our DG comes to come and have an imbizo. We have extensive exhibitions. We visit schools, Chairperson, in all the provinces. We have regular radio and television presentations. And we also explain the process. At that stage, Chairperson, many people come to us and say, this is what was wrong, and this is what was wrong, and that is what was wrong. I think we take details and we give feedback. Just not so long ago, Chairperson, the minister's office sent me an email to say, and a WhatsApp to say that somebody didn't get her money, and she knows that payment is happening from the husband's salary into the department's account. We undertook to respond within 24 hours. We managed to find the money. We found the money where it was on the system. We communicated back to the minister's office within 24 hours, and in probably either by today or tomorrow, I can confirm that the lady received her money. And that's the manner in which we want to work, Chairperson, within hours and days and not months, to have to receive people's money. We know where the money is, we can find it on our system, and we urge people to advise us when they change their bank accounts or when they change addresses, etc., Chairperson. Next. Thank you, Chairperson. And honorable members, I think I'm done. Suffice to say that top of our agenda in the Department of Justice, which is the Poverty Alleviation Project, is to ensure that our maintenance systems and processes and procedures are working properly and smoothly. One very important matter that I need to mention at this stage, or let's say two, Chairperson, which is the last two, is that we would like to equip our maintenance officers, maintenance investigators, and maintenance clerks, and hopefully lots of staff in our courts with mediation skills. Many of our cases are settled on the basis of two parties arguing for about an hour to two and then agreeing to settle it. And we have a situation whereby we have somebody with an LLB who just focuses on the legal. But the mediation skills are skills of convincing, skills of bringing the parties together, skills of presenting a win-win situation. And that can help us work down our backlogs and bring our maintenance cases into a state of current, which then enables us to move faster. I just need to say that we added as a key performance indicator that a maintenance case from proper service of summons must be done within 90 days. That was our key performance indicator. We also set as our level, I think, I speak under correction, I think 90% of such applications per month must be finished within 90 days. We had as our key performance indicator that a maintenance investigator needed to find someone within 90 days. We brought that down to 60 days because we thought if the application is going to go for 90 days, which is equivalent to 3 months, if an investigator is going to take 90 days. So we thought of bringing it closer to 60 days. And those are our standards currently at the moment, which we measure ourselves and report to our EXCO on a monthly basis, Chairperson, and they are in systems, so it can be checked, Chairperson. Then finally, Chair, we are also working on the rationalization of the processes and procedures. Maintenance just takes too long. There's just too much things that needs to be handed in and submitted and forms filled in. So we're looking at the process. I think this is also part of the Law Commission's responsibility, and we are looking forward to their final report. Thank you very much, Chairperson.
Thank you very much.
Maybe Chair, briefly, thanks, Mr. Isaacs, just to just round it off without taking much of the time. Just to mention, but not to belabor it, that we seriously have a capacity constraint. This unit is understaffed, even in head office. It's just 1-2 people handling this matter. But just even the deployment of maintenance investigators, because I think for years since the Act came into operation, it was done more in a pilot format. So there's been a transition for a long time. So part of what the Indaba, the National Indaba we had internally was also to review the Act and look at how far we have gone in the implementation, but in building the capacity in the department. It's unfortunate because of the current economic climate and the treasury cost containment measures, we will not be able to improve the capacity. So the challenges, the outcries there in terms of service delivery are not due to shortage of skills, neither incompetence, but it's simply a question of not having a capacity. We just hope that with the austerities that will be implemented, we will not even won't find ourselves in a situation where that as maintenance investigators and officers leave for greener pastures, we're not even able to replace them. And finally, in the next coming weeks, part of what we have from our modernization program, we're looking at launching a maintenance online. I think colleagues from ICT have made significant progress in developing the capability, the software for maintenance online. And I think Mr. Isaacs mentioned some of those related matters, at least to assist with the queues generally, or the unnecessary visits to the service points, so that those that are able to access the system in the comfort of their homes can do that. Chair, we thought just we needed to reflect on that. Thank you very much.
Okay, thank you very much, DG and the acting DDG in the Department of Justice for the presentation. But I understand that we only received one presentation which speaks to child maintenance, but we're also supposed to be receiving a briefing which speaks about Children's Act. So I'm not quite sure whether you'll just take us through the Act quickly on where the amendments were done based on the public hearings, so that we can be able to discuss and engage both presentations. So I'm not sure who's going to present for the department. Did you?
Mr. Isaacs, there might have been a miscommunication. Our brief seem to have been about the Child Maintenance Act. Mr. Isaacs, do you?
DG and Chairperson, Honorable Chairperson, no, we did not do a presentation or for the Child Justice Act. At this stage, we and I wouldn't like to venture and mislead or give you a half a picture. We most comfortable to come back at your convenience, Honorable Chairperson.
Okay. Thank you very much, Mr. Isaac. I see a hand of Kamogelo. You can come in before we can engage the presentation.
Recording stopped. Recording in progress.
Good afternoon, honorable members of parliament. I do want to support Mr. Isaacs in saying that the letter of invitation that we got was only in respect of maintenance. And just to kind of correct the Children's Act, it's in the mandate of the Department of Social Development. They are the ones who are seized with the review of the Children's Act. We are only responsible for maintenance as well as Child Justice Act. Thank you.
No, it's fine. Probably the confusion might have been on my side. I've just been clarified now by the committee secretary that in fact this was the presentation I was supposed to receive. So I'll allow members to engage on the presentation. You can raise your hand so that we're able to note you. Honorable members. Or does it mean the presentation? Oh, I see the hand of Honorable Sheriff. Any other hand? If you are struggling to use to raise your hand in the gadget, you can also indicate, then I'll be able to note you. Honorable Sheriff.
Thank you very much, Chairperson. Sorry for the delays. My network is a bit shaky. I'm stuck with the 4-hour load shedding time slot, so my electricity is only going back at 8:30. Chairperson, thank you to the DDG for the presentation and for the department to coming to the Multi-Party Women's Caucus Steering Committee. Chair, mine is more of a comment than it is a question. This thing of child maintenance is such an incredibly important issue. Oftentimes, the lack or the consciously withholding of maintenance is abusive. And I would argue that it is part of financial abuse that perpetrators would put victims through. And to hear that this unit is undercapacitated and under-resourced is a great shame. And if the DG doesn't feel like that's going to change anytime soon, Chairperson, then I think we do have a problem. You see, the thing about the country that we live in, there are some people who can hire lawyers and go after their maintenance, and there's a majority of people that simply cannot, and they rely on departments to give them assistance so that their child can live somewhat of a decent or have a decent standard of living. I would urge for the department to really, really go back and reconsider the importance of this maintenance unit and the real life struggles that mothers and single fathers go through when trying to and going to courts and going through all these processes and taking years and years and eventually just giving up because the system in itself is the patriarchy and the system itself is geared towards the discrimination and the unequalness of gender in this country. So, Chairperson, of course, when we take this to the full multi-party women's caucus, I would like to suggest that one of the recommendations from us be that this unit be capacitated, be resourced, and properly funded so that women and single dads, single parents can actually get assistance. At the end of the day, if you're having children, you need to pay for them. People must pay their pap child. Thank you, Chair.
Thank you, Honorable Sharif. I fully agree with the recommendation. I mean, if processes they take time to be implemented, it's very frustrating on the other part, especially the complainant in regards to the child maintenance issues. But mine is just one. I don't know if you'll be able to respond to that. I just want to check, is there a system that determines, let's say there's a judgment that the other part, one of the parents that is not maintaining the child, that they must maintain their child. Is there a percentage? How is it calculated? Well, some of the judgment would find that they just appear as a by the way, given the fact or given the amount that it actually should be paid by the other person in maintaining the other child. So in some cases, it feels a bit unfair because it can even go as little as 300 rand. So I just want to know the mechanism. Obviously, I might not be speaking to judges, but of course, in the Department of Justice, you might have a bit of a clue with how is that money determined in terms of the percentage that must be paid to a child. I think you are now allow the department to respond. Don't know whether DG would like to come first and then be followed by the acting DG.
Thanks, Chair and honorable members. Maybe just the first part on the recommendation. It's not that we don't take the maintenance matters serious. We are looking at different options with the DDG on how we can improve the presence. But the reality that we have now, the letter we got from Treasury is very scary. That basically says that there won't be money to assist or to resource any unit in the department. So that's the biggest challenge. The biggest fear I was expressing is that will also mean that even the officials that keep on looking for opportunities to leave the maintenance unit to go somewhere else, either for promotion, it might well mean a further reduction of that capacity. But if it was the committee helps us as well with Treasury to give us resources, we will very much welcome that. Mr. Isaacs, can you deal with the second question that relates to the judgment?
Thank you, Chairperson. I'm sure Kamogelo will also come in. Honorable members, Honorable Chairperson, I think it is a merit matter from case to case. It depends on the value income of the parties the law is very clear that both parties must support. Many times the child is in the custody of the mom, where, let's just for example say so, and where the mom normally pays the lights, the water, the schooling, the bus, the taxi, the clothing, the food, the extras. And then that amount of input by the mom is pro rata allocated to the child. And that then it is determined what the father earns in order to match that pro rata. That's one way. Then there is the other way of the pro rata contribution by the mother from her salary point of view, and the pro rata contribution from the father of his salary point of view. But obviously keeping in mind the financial responsibilities of the mother and the financial responsibilities of the father. So as I said at the very start, it depends from case to case. One gap in the legislation of the Maintenance Act is that there are or were no formulas set out or guidance on determining the quantum of how to determine this amount that is needed between the two parties to pay. Chairperson. So yes, unless I'm given the mother and so the father and so these are the responsibilities of each. Unless I'm given that set of facts, I'm basically going to give you a generic answer. We also take note of the fact that the father has so many children, the mother has so many children. They either a boyfriend, girlfriend, or they are separated or divorced with other families, etc. All those things are taken into account. The luxuries, the outstanding accounts on the luxuries, etc. And what needs to be disposed of in order to ensure that the money comes forward. There is also future maintenance applications that are brought by maintenance officers in order for that monies of an estate or a pension to be taken and set aside in a specific account in the department and National Treasury, where the money is put away or by the master's account. And that money then pays the child on a monthly basis. The pension is also attached when you know that there's a pension application coming. The pensions department indicates that they are not a collections agency. So either the parties are going to agree and the maintenance officer brings an application and makes an assessment of a very, very unqualified assessment, or not necessarily an actuarial assessment of the child's maintenance needs, and that amount is then attached before a pension is paid out, Chairperson. So that's as far as the money management is concerned, Chair. Thank you.
Okay, thank you very much, Acting DDG. Just to also check if the other parent is not satisfied about the judgment, are they afforded an opportunity to appeal? I don't know, am I audible?
Yes, Chairperson, you are. I had your question. I'm sorry, I must just learn to mute and unmute myself here. Kamagelo, would you like an opportunity to speak in respect of the appeals and reviews?
Yes, thank you, DDG and Chairperson. I would like to go back to a response regarding the quantum of maintenance to be paid and whether there is calculations. As part of the South African Law Reform Commission, proposals were made that there should be calculations. So we are hopeful that the Law Reform Commission report will assist us somehow to get some kind of level of certainty as to how the quantum must be calculated by magistrates, so that we don't have such varying maintenance orders for people earning similar salaries or in similar financial standing. And then in as far as determining whether there is review. It is unfortunate that the Act as it currently stands, it is only talking to appeals. And as we know, predominantly we have women being the primary custodial parents for children, and most of them are economically unable to appeal. But on the other side, on the flip side, we find that respondents play the system by continuously, in some cases, continuously appealing against certain aspects of the maintenance, such as jurisdiction. So in the South African Law Reform Commission report, it will also address the reviews. And from my slide glimpse of the preliminary report, it shows that they are pro establishment of a review process. But nothing stops a complainant to take a case on review. And we are currently assisting a magistrate because a respondent took a case on review based on jurisdiction, and an order was awarded against a magistrate personally to pay cost regarding issues of jurisdiction. So the state attorney will be possibly supporting the magistrate to challenge the decision of the review. So we accept that there are challenges, but a lot of work has been done in the South African Law Reform Commission to try and address the niggling challenges that the public and us in the department have identified. Thank you.
Thank you very much, the Department of Justice, on your responses. Let me also check with the honorable members whether one would want to have a follow-up or a second bite, or we are happy with the responses in terms of the Child Maintenance Act. Any hand? Honorable Sharif?
Chair, I'm sorry, you feel free to call me out of order if I had missed this in the presentation, but I'm just curious to find out from the department, what is their success rate in terms of the cases that they take on, and taking it as far as, you know, a constant payment that is happening to the child and to the single parent, in terms of stats versus how many cases that they have and how many cases. I don't want to say one, but like, I think you know what I mean. Thank you, Chair.
Okay, thank you. The department?
Chairperson, I'm going to ask Kamagelo, do you have any information on this matter? And Chairperson, I must admit that we actually should have come to this meeting also with the stats. But let me hear what Kamagelo's got to say, Chair.
Okay. Thank you, Chairperson. Thank you, DDG. Thank you, DG. I think we need to be circumspect about saying the total success rates. I will talk about the total success rates based on the key performance indicators that we are having. As a precursor, I just need to state that most of the cases, the majority of the cases, more than 80% of the cases are consent order, are actually concluded through consent order agreements, meaning that they don't really go to Section 10, where a formal inquiry is held in court. So we could say about 20% of the cases are contested cases, and they are the ones that are giving us most challenges, and we must admit that we are really, with those cases, we work hard with maintenance investigators to make sure that we collect evidence. So in terms of the 90-day turnaround key performance indicators, We are succeeding between currently 89% and 90%. And we have, I think we're falling short by 2% to reach our target. And we hope that with the training or workshops that we will be having with the courts that are underperforming, we will be able to raise the bar. And it is concerning that we should say that some of the courts that were previously overperforming are no longer overperforming because there are vacancies that cannot be filled, that have not been filled. And we have also recently introduced a target for investigations to say that we can't have open-ended investigations and we need to monitor that the investigations are concluded. So currently we are still struggling in this area, but for the courts that are really equipped, we are doing very well with the reports that are collected. I mean, with the courts that are providing us data, we are able to conclude our investigations where instructions are given within 60 days in most of the courts, at about 80% as well. But we must admit that this particular key performance indicator, we need to, it's one of those where we are going to have to focus on intensive training. And the presentation by the DDG, acting DDG, that we are partnering with FNB is a key one that will enable maintenance investigators to be able to track, because people move funds from one bank account to another. And to be able to decipher the connections between ABSA and FNB and Nedbank, so that you can say that as we follow the money throughout the banks, we realize that this particular respondent presented us a banking statement that shows that he has no money, but on further in-depth analysis and Section 205 inquiries through the banks, we have found out that this money is moved around to basically present a dire statement. But we believe that through the FNB training, we are going to have most of our investigators being able to analyze statements from bank to bank and basically follow the money with ease. Thank you.
Thank you very much, Ms. Kamogelo. Members, I think we have satisfied ourselves with the presentation. If there is no any other issue that is arising, I would then release the department for us to continue with the business of the committee. Are there any other outstanding issues, honorable members? So I suspect there's no any other issue that is rising up. Thank you very much to the Department of Department of Justice, DG, and the acting DDG, and your team for making your time and coming to present to us in terms of the Child Maintenance Act. We really appreciate your presence in our meeting. So you are allowed to stay if you want to stay, but you are excused for now. Thank you very much. We'll
Thank you very much, Honorable Chair and members.
Thank you.
Thank you. Mandy, can you fly the agenda? So let me see the next item. It's the adoption of the 29th August 2023 draft committee meetings. Can you flag them? And they were distributed prior to the meeting. I believe that members, they did go through them. Okay, this is the first page. Anything you want to add? Okay, go up, Mindy. Okay, the summary of outcomes and decisions. 1, 2, 3, 4. Anything want to add? Or any matter arising from this? Okay, you can move to page 2. This was the minutes of the proceeding, opening and welcome, apologies, agenda, appointment of committee researcher, adoption of committee meetings, or minutes, sorry. Can go up. Overview of the adopted parliamentary program. Salga Women's Commission Lekgotla. The closing remarks in the adjournment. So, honorable members, are there any, was there anything that was omitted in the minutes that we feel we must add? If not, I'd like to have a person that will move for the adoption of the minutes. Welcome, Chairperson. I see you are connected.
Thank you, Whip.
Any mover for the adoption of the minutes? Doctor, you're so quiet today. Dr. Teberoy. Any mover?
I move for the adoption of the minutes, Whip.
Any seconder? Thank you very much, Chair. Any seconder? But they can't be having members of the committee, they are quiet throughout, unless they are missing in action. Just connect, put the gadget there, then the meeting proceeds. Can we have the seconder of the minutes, honorable members? I don't know what this means, Chair, you must advise. Because we've got Dr. Timiwayo, Honorable Sharif.
Oh, Chair, I will second the minutes.
Thank you. Thank you, Honorable Sharif. At least we liberated as we were stuck there for a second, for a minute.
Hi, Chair. All I seem to do is propose adoption and secondment.
Thank you so much, Honorable Sharif. The minutes are adopted. Can we move to the last item of the agenda? Which is closing remarks and adjournment. Thank you very much, comrades, for making your time and attending this meeting. There's nothing further that I will elaborate on. What I can say is that have a good evening and the meeting is adjourned. Thank you very much.
Thank you, Chair.
Thank you, Chair. Goodbye.
Bye. Get better, Chair.
No, I'll be fine, my dear. I'll be fine. Thank you so much.
Get well soon, Chair.
Okay, bye.
Bye.